The Task Force to Investigate Terrorism Financing will come to order. The title of today's task force hearing is the Iran nuclear deal and its impact on terrorism financing. Without objection, the chair is authorized to declare a recess of the task force at any time. Without objection, all members will have 5 legislative days within which to submit extraneous materials to the chair for inclusion in the record. Without objection, members of the full committee who are not members of the task force may participate in today's hearing for the purpose of making an opening statement or questioning the witnesses. The chair now recognizes himself for 3 minutes for an opening statement. Over the first several hearings of this task force, members have heard foreign policy experts and others testify regarding the pervasiveness of Iran's involvement in the financing and exporting of terror throughout the Middle East and around the globe. We know that Iran is the leading state sponsor of terror, and as such, any diplomatic engagements with Iran or understanding or agreements with them would be incomplete without a clear and full understanding of these facts and its impact on the face of global terror financing. Today's hearing will explore the recently announced nuclear agreement negotiated by the Obama administration and the P5+1 nations with Iran, specifically its impact on terrorism financing through and by Iran. Most concerning to many members of this bipartisan task force is the easing of congressional sanctions, and with it the danger that a new influx of cash will find its way to terrorist organizations threatening to strike the United States of America. It appears this agreement fails to address the reality surrounding Iran's sponsorship of terror while further empowering its mullahs by infusing billions of dollars into the economy through the lifting of sanctions that successfully brought Iran to the negotiating table in the first place. The Iranian regime has demonstrated a lack of concern about its own people, leaving in doubt the estimated $150 billion in funds currently held abroad will allow the Iranian economy to fully recover, not to the benefit of the oppressed citizens, but to the advantage of the next generation of terror syndicates. A nation so deeply committed to promoting terror has lost its right to good faith agreements. That is why, over the next 2 months, members of both the House and the Senate will review the fine points of this agreement before voting on it, the product of the bipartisan passage of H.R. 1191. It is my hope that this hearing, both the questions asked by the members and the testimony of our witnesses, provides vital information for Congress and the American people when looking over this nuclear deal. This agreement will determine the future of our nation's foreign policy and the global balance of power. It is far more significant than a presidential legacy or the political goals of any party and cannot take place with an eye on the next election or an ideological allegiance. Republicans, Democrats, and independents alike hold the power to turn back a bad deal, and I'm confident that this task force, rooted in bipartisanship, will play an important role in the decision-making process. This time I'd like to recognize the task force's ranking member, my colleague from Massachusetts, Mr. Lynch, for an opening statement.
Thank you, Mr. Chairman. I also want to thank our esteemed panel here for your willingness to help the committee with its work. Last week, Iran and the P5+1, which I hate using acronyms, but it includes the United States, the UK, France, Russia, China, and Germany, finalized a joint comprehensive plan of action that attempts to ensure that Iran's nuclear program can be used exclusively for peaceful purposes, and in exchange for a broad suspension of many U.S., European, and United Nations sanctions. I'm pleased that today's hearing will present our task force with the opportunity to hear from experts with varying perspectives on that deal. While there is no such thing as a perfect negotiation that leads to a perfect deal, I think that with proper implementation and compliance, there's a great deal of good in this deal. I cite Section 3 of the deal, which I find particularly comforting, and it says that Iran reaffirms that under no circumstance will Iran ever seek, develop, or acquire any nuclear weapons. Of course, in the next section, the agreement guarantees that Iran will have the ability to develop a peaceful energy-related nuclear industry. In exchange for some sanctions relief, primarily related to oil and banking, and as well of obtaining nuclear weapons release for at least a decade, sanctions related to terrorism and human rights abuses will remain in place. I am cautious but hopeful that we can make this deal work. I believe there are still some questions that need to be answered. Of particularly concern to our task force is how to ensure that the approximately $100 billion in frozen assets do not flow to terrorist organizations. The State Department has designated Iran as a state sponsor of terrorism since 1984 and notes that Iran continues to support Hezbollah and the Assad regime in Syria, as well as Hamas, Islamic Jihad, and others. On the other hand, the multi-layered sanctions imposed by the U.S. and its allies have weighed heavily on the Iranian people. Treasury Secretary Jack Lew recently stated that Iran's GDP shrank by 9% in the 2 years ending in March 2014 and is now 15 to 20% smaller than it would have been without the sanctions. Iran's oil, coal, auto, aircraft, financial, and textile industries are reeling from U.S.-led sanctions, and due to the embargo on aircraft components, visitors have regularly expressed dread at the prospect of flying within Iran because of the woeful condition of their domestic airlines. Iran's policies have brought isolation and few allies. Many experts view the election of President Hassan Rouhani, the relative moderate candidate in that last election, as an expression of Iran's desire to move in a new direction. Sanctions relief could provide an opportunity for Iran to rebuild its economy and invest in infrastructure and embracing that moderate future. While the opportunity is here, the trust necessary to move forward is not. Fortunately, I believe this agreement does not require us to place our trust in Iran. Under the deal's terms and its roadmap for clarification on nuclear issues in Iran, this entire agreement hinges on the adoption and implementation of a rigorous International Atomic Energy Agency inspection, monitoring, and guidance procedure. Indeed, the agreement relies more on the IAEA inspectors, and it's good to see Ollie Heinonen here, someone who knows a little bit about that, than any other party, because in the absence of trust, we will need the IAEA's assurance that Iran will remain in compliance. While we should move forward with care and every precaution for ourselves and for our allies, I believe we should move forward. Mr. Chairman, I yield back the balance of my time.
Now recognize the Vice Chairman of the Task Force, Mr. Pittenger, for an opening statement for 1 minute.
Thank you, Mr. Chairman. Thank you for calling this meeting. This agreement, without question, has the most grave outcomes of any agreement negotiated by this government. Our allies in the Middle East, those whom I have met with on countless times, Prime Minister Netanyahu and other leaders of the Arab world, are gravely concerned with the outcome. They know their neighbor. They know and have watched Iran over the last 35 years is the greatest exponent of terrorism. Of course, each of us has concerns over the inspections, but clearly this body today is going to address the terrorism financing capacities that they'll have with $100 billion. No less than National Security Advisor Susan Rice, General Dunford, who is President Obama's nominee to be Chairman of the Joint Chiefs, have expressed those same concerns, that this funding would be used for the purposes of building the military and terrorism financing. So I look forward to our discussions today, and thank you, Mr. Chairman, for calling this meeting.
I now recognize the Gentlelady from Arizona, Ms. Sinema, for an opening statement of 2 minutes.
Thank you, Chairman Fitzpatrick and Ranking Member Lynch, for holding this very important and timely hearing. A nuclear Iran is one of the greatest threats to security of the United States and to peace and stability in the Middle East. To support this deal, the agreement must end Iran's nuclear weapons program and strengthen the safety and security of both the United States and our allies in the Middle East. This deal, if Iran does not cheat, prevents Iran from obtaining a nuclear weapon for 10 to 15 years. However, I have several concerns about the deal's structure, planned execution, and broader implications. Several questions. Number one, is the United States confident in the success of the verification regime established by this agreement? Number two, what is the exact timing of sanctions relief by the United States and the EU? And once these sanctions are removed and foreign investment floods into Iran, can we be confident that sanctions will snap back into place if or when Iran cheats? Number three, what are the broader consequences of this agreement for our security and regional stability? And how will an influx of billions of dollars affect the geopolitical balance in the Middle East? Iran is the #1 state sponsor of terrorism, and the current regime is a destabilizing force in the region. Taking our most effective sanctions tools, the banking and energy sector sanctions, off the table could limit our ability to counter Iranian aggression, stabilize the region, support our allies, and avoid military conflict. Fundamentally, I seek to understand whether this deal prevents a nuclear Iran for 15 years with long-term positive change in the region, or whether it could allow Iran to further destabilize the region using financial resources and new non-nuclear weapons while becoming an empowered nuclear threshold state. Over the next several weeks, Mr. Chairman, I know we'll all thoughtfully and thoroughly review these details of the agreement, including the comments coming from Iran. And I want to thank the Chairman and the Ranking Member for holding today's hearing, and thank our witnesses for coming to share their expertise views with us today. Thank you.
Gentlelady from Missouri, Ms. Wagner, is recognized for 1 minute.
Thank you, Mr. Chairman, and thank you, Ranking Member, for calling this timely meeting today and hearing. We've just left our classified briefing, so it couldn't be more timely. And I thank you, Mr. Chairman, for sounding the alarm about the mistake, I believe, of historic proportions agreed to by the Obama administration last week in Vienna. The President has agreed to far-reaching concessions in nearly every area that was supposed to prevent Iran from acquiring a nuclear weapon. Under this deal, Iran would receive $100 to $150 billion in sanctions relief and regain access to conventional arms and ballistic missiles that has been denied for nearly a decade. Iran will be free to transfer these weapons, as has been stated, to Hezbollah, the Syrian government, Yemeni rebels, and other terrorist groups. These organizations threaten the security of the United States, our ally Israel, and the world, and will further destabilize a region already in crisis. As Prime Minister Netanyahu said when visiting Congress earlier this year, no deal is better than a bad deal. By any measure, this is a bad deal, Mr. Chairman. Congress should show the world that America will not accept a nuclear Iran. I yield back and thank you.
Gentlelady yields back. We now welcome our witnesses. Elon Berman is Vice President of the American Foreign Policy Council. Mr. Berman has consulted with the Central Intelligence Agency and the Department of Defense and provided assistance on foreign policy and national security issues to a range of governmental agencies and congressional offices. He's a member of the Associated Faculty at Missouri State University's Department of Defense and Strategic Studies. He also serves as a columnist for Forbes.com, The Washington Times, and as editor of the Journal of International Affairs. Mark Dubowitz is Executive Director of the Foundation for Defense of Democracies and Director of its Center on Sanctions and Illicit Finance. He's an expert on sanctions and has testified before Congress and advised the administration, Congress, and numerous foreign governments on Iran and sanctions issues. He holds a master's degree in international public policy from Johns Hopkins University's School of Advanced International Studies and Law, and an MBA degree from the University of Toronto. Stephen Perlis is senior attorney and founder of the Perlis Law Firm. Mr. Perlis has handled a number of cases before the United States Supreme Court, United States Courts of Appeals, and district courts across the country. His litigation practice has included cases in the fields of Foreign Sovereign Immunities Act litigation. He has lectured on the evolution of anti-terrorism civil litigation at conferences for national crime victims groups. He holds a law degree from the William and Mary Law School. Dr. Ali Hananen is a senior fellow at the Belfer Center for Science and International Affairs at the Harvard Kennedy School of Government. Before joining the Belfer Center in September of 2010, Dr. Hananen served 27 years at the International Atomic Agency in Vienna. Dr. Hananen served as the Deputy Director General for the IAEA and head of its Department of Safeguards. Prior to that, he was director at the agency's various operational divisions and was an inspector at the IAEA's office in Tokyo, Japan. He studied radiochemistry and completed his PhD dissertation in nuclear material analysis at the University of Helsinki. Dr. Richard Nephew is a program director of the Economic Statecraft, Sanctions, and Energy Markets Center on Global Energy Policy at Columbia University. Prior to this position, Dr. Nephew served as the principal deputy coordinator for sanctions policy at the Department of State. He also served as the lead sanctions expert for the United States team negotiating with Iran. From May 2011 to January 2013, he served as the Director for Iran on the National Security Staff. He holds a master's degree in Security Policy Studies and a bachelor's in International Affairs from George Washington University. The witnesses will now be recognized for 5 minutes each to give an oral presentation of their written testimony. Without objection, the witnesses' written statements will be made part of the record following their oral remarks. Once the witnesses have finished presenting their testimony, each member of the task force will have 5 minutes within which to ask the witnesses questions. On your table, there are 3 lights, green, yellow, and red. Yellow means you have 1 minute remaining, and red means your time is up. The microphone is sensitive, so please be sure that you're speaking directly into it. And with that, Mr. Berman, you are now recognized for 5 minutes.
Thank you, sir, and thank you, Mr. Chairman and Ranking Member Lynch and distinguished members of the task force for the opportunity to be here today to speak to you on a truly critical issue. There's a great deal to say about the Joint Comprehensive Plan of Action, as the new agreement with Iran is formally called. I simply don't have the time to say it all, and on issues like verification and compliance, I think my colleagues can acquit themselves much better than I. So if I could, I'd like to devote my time to talking about one issue in particular, which is the threat potential of the Iranian regime and how it will change and expand as a result of the JCPOA. This relates directly to the question of sanctions relief, because under the agreement, the Islamic Republic is now poised to receive massive economic stimulus in the very near future. Specifically, later this year, or at the very latest, early next year, upon verification by the International Atomic Energy Agency that Iran has disclosed the requisite details of military-related nuclear work, the U.S. will begin unblocking $100 to $150 billion of Iranian revenue from oil sales that have been locked in escrow accounts in China, South Korea, and in other nations. I think it's necessary to put this sum in context precisely because it is so large. In 2014, the U.S. government estimated that Iran's total annual gross domestic product was $415 billion. So what we're talking about here is a quarter, roughly, of Iran's annual GDP. I think with very little exaggeration, what we're talking about here is a Marshall Plan for the Islamic Republic, the financial equivalent thereof. And while White House officials have expressed hope that the Iranian regime will use these funds to focus internally, to focus on domestic conditions, on improving the economic welfare of ordinary Iranians, it's necessary to point out that money is fungible. And an Iranian regime that has this kind of economic stimulus package has an unprecedented financial windfall that will invariably translate into greater capability in 2 areas. The first area is terrorism. Several years ago, the U.S. government publicly estimated that Iran had, quote, a 9-digit line item in its budget for support of terror organizations, end quote. This included $100 to $200 million annually to Lebanon's Hezbollah, as much potentially as $25 million monthly to Hamas in the Palestinian Authority, and the list goes on. And this assessment was made at a time when Iran was subject to stringent international sanctions, and there was no financial relief for the Islamic Republic in sight. Today, the situation is very different. The resources at Iran's disposal in this area are poised to expand exponentially. And as a result, what you see is a much greater potential on the part of Iran to translate its financial windfall into a financial windfall for its proxies. The second issue of particular concern to me is the question of Iranian regime expansionism. The Iranian regime possesses a distinct manifest destiny. Ideologically, it talks about itself as the center geopolitically of the Middle East. And it has launched, even in absence of sanctions relief, it has launched an ambitious effort to expand its influence globally, but in particular in the Middle East. What this looks like in practice is a massive investment in propping up the Assad regime in Syria, which has been estimated to cost the Iranian regime something like $6 billion or more annually. The Iranians have provided extensive military and economic backing for Yemen's Houthi rebels, and primarily, although not exclusively, but primarily because of Iran's assistance, the Houthis have managed to change fundamentally the power dynamic in that country, and Iran has become a key power broker in Yemen's future. And the same holds true in Iraq, where Iran already possesses extensive political influence. The current fight against the Islamic State terrorist group and the disarray of Iraqi politics has allowed Iran, through both economic and military and financial means, to expand its ambit still further. So what should we expect here? The Iranian leadership already believes that it has an unprecedented opportunity to dominate the region. The Iranian Supreme Leader, Ali Khamenei, said as much in September of 2014 when he declared publicly that the power of the West on their two foundations, values and thoughts, and the political and military have become shaky and could be subverted. Now, with the conclusion of the nuclear deal, Iran is poised to have greater resources to accomplish this than ever before. And this gets us to the question of what we expect. The White House has said in public that this deal is merely transactional. It's focused strictly on the nuclear issue and doesn't touch on other issues, including Iran's support for terrorism. But both in scope and in duration, and frankly, in its material minutia, what you see is a deal that's aspirational. It is one that hopes that the Iranian regime will, as a result, turn over a new ideological leaf. But this is not how the deal, how the framework agreement is being read in Tehran. As the Iranian Supreme Leader himself said several days ago, Iran remains steadfast in its opposition of the United States, as well as its efforts to reshape the region in its own image. So what we end up with is a situation where, although Iranian belligerency remains unabated, the Iranian regime, through the JCPOA, now has dramatically greater financial tools to accomplish its goals. Thank you.
Mr. Dubowitz, you are now recognized for 1 minute.
Great. Thank you, Chairman Fitzpatrick, Ranking Member Lynch. On behalf of the Foundation for Defense of Democracy's Center on Sanctions and Illicit Finance, it's an honor to testify before you and your task force, and an honor to be testifying with these distinguished experts. I want to focus on the Revolutionary Guard Corps, the IRGC, which I think is the major beneficiary of this nuclear deal. And this nuclear deal itself is fundamentally flawed in its both design and architecture. As a result of these artificial sunset provisions, the IRGC, in fact, which controls Iran's nuclear and ballistic missile programs, has patient multiple pathways to developing nuclear weapons and regional power. Again, as long as it's patient and faithfully complies with the agreement, Iran over time will develop an industrial-sized nuclear program, the near-zero breakout, an advanced centrifuge-powered sneak-out pathway, and multiple heavy water reactors. Iran will be able to buy and sell heavy weaponry with the expiration of the arms embargo. Iran will also be able to develop long-range ballistic missiles, including an ICBM. And let's be clear that most of the economic sanctions are being dismantled, unlike the nuclear program. Now, I'm focusing on the Revolutionary Guards, again, because they are the major beneficiary. And Mr. Chairman, last spring, FDD provided the US and UK governments with a database of 1,290 IRGC companies and individuals. The full lists are in my testimony. I'd ask them to be please entered into the record. After 16 months, the U.S. has not sanctioned any of these IRGC entities or individuals. And the non-listing of these entities provides the IRGC with economic benefits and the ability to operate without restrictions. So the IRGC stands to benefit even more now because of the JCPOA. The deal requires the U.S. and Europe to remove numerous IRGC-linked entities from their sanctions lists, including the most important terrorism finance and money laundering facilitator, the Central Bank of Iran. Most Iranian banks, including some IRGC-controlled banks, will be permitted back onto the SWIFT financial messaging system, giving Iran's most dangerous actors access to the global financial system. This is deeply troubling because the IRGC, again, the most dangerous actor in Iran, controls at least 1/6 of Iran's economy, including major strategic sectors. Now, these delistings are a direct challenge to the conduct-based nature of the sanctions regime imposed by the Obama and Bush administrations. Those sanctions were designed to target the full range of Iran's illicit activities, and not just Iran's nuclear program. And they're also designed, according to Treasury officials, to protect the integrity of the U.S. financial system. This is made clear when Treasury issued a finding under Section 311 of the USA Patriot Act, which found that Iran's financial sector, including its central bank, was, quote, a jurisdiction of primary money laundering concern. Treasury cited Iran's, quote, support for terrorism and the use of deceptive financial practices. In short, the entire country's financial system, quote unquote, posed illicit financial risks for the global financial system. Internationally, the Financial Action Task Force confirmed these terror financing and money laundering risks. Though the 311 was conduct-based, this agreement now calls for sanctions relief without a demonstrable change in Iran's behavior. This mass delisting includes nearly 650 entities, many involved in Iran's nuclear and ballistic missile programs. More than 67% are going to be delisted from Treasury's blacklists within 12 months. After 8 years, only a quarter will remain on our lists. In 8 years, the U.S. and the European Union will lift sanctions on Abbasi Davani and Mohsen Fakhrizadeh. They are the Robert Oppenheimer and A.Q. Khan of Iran's nuclear weapons development, and Gerhard Visser, who actually helped run A.Q. Khan's proliferation network. The EU will also lift its nuclear sanctions on notorious Quds Force commander Qasem Soleimani, though he will remain on the EU's terrorism list for now. The deal lifts U.S. sanctions on 47 Iranian banks designated for proliferation, nuclear, and ballistic missile activity, or for providing financial services to other delisted entities. They're all going to get back onto the SWIFT financial messaging system. Now, the White House assures us that they have a snapback mechanism, or that they can impose non-nuclear sanctions like terrorism. But the agreement itself notes that Iran may walk away from the deal and its nuclear commitments if new sanctions are imposed. The agreement also contains an explicit requirement for the European Union and the United States to not interfere with trade and economic relations with Iran. So Iran can use these provisions to argue that the reimposition of sanctions, even if implemented on terrorism grounds, is a violation of the agreement. Iran will threaten to return to its nuclear program, and this gives Iran an effective nuclear snapback, much more powerful than our economic snapback, to intimidate the United States and especially Europe from reinstating sanctions. Now, Iran has talked about the hundreds of billions of dollars that are going to go back to Iran, and with Iran back on the SWIFT system and its banks reintegrated into the formal financial system, halting the flow of these funds to bad actors will be challenging. In short, Congress should require the White House to renegotiate and resubmit an amended deal for congressional review that addresses these weaknesses, including the snapbacks and sunsets, which are dangerous design flaws of the agreement. Mr. Chairman, I'm happy to share some of the other recommendations in my testimony during Q&A. Hopefully this is a good start, and thank you for the opportunity to testify.
Thank you. Mr. Perlis, you're now recognized for 5 minutes.
Thank you very much. Mr. Chairman, Ranking Member Lynch, Mr. Pettinger, thank you again for the invitation and the honor to testify before you today. Over the last 20 or 30 years, my law firm has probably represented and reconstructed terrorist attacks involving the death or personal injuries to U.S. nationals than perhaps the rest of the private bar combined. We have extensive experience reconstructing and then litigating these matters against countries like Libya, Syria, Iran, and the Sudan. Our litigation portfolio is currently valued at about $17 billion. During the course of that period, we have separated roughly $500 million from the material supporters or financiers of these attacks, and we currently hold $1.9 billion of Iranian assets that were illicitly invested in New York in our trust account, awaiting final court orders so that they can be distributed to various clients. I was asked to testify for a very explicit and narrow question of expertise. In my view, my opinion, will the release of $100 billion to Iran result in an increase in Iran's funding of terrorist organizations, resulting in the future deaths and personal injuries of United States nationals? I think based on Iran's behavior that I've looked at since 1979, the answer to that question is inevitably yes. There will be substantial increase in funding for those organizations, and they will target U.S. nationals. In a perverse way of looking at this, Secretary Kerry's next objective in the world diplomatic arena is the Palestinian peace process. If you study, as we have because of our client portfolio, the Oslo peace accords, which were negotiated in the mid-1990s, you come to the inevitable conclusion that there was real peace in the Middle East at the conclusion of Oslo, and that the Iranians could not tolerate peace in the Middle East. It's not consistent with their foreign policy view of how the Middle East should be mapped. Being unable to tolerate peace in the Middle East, the Iranians sponsored a bus bombing campaign designed to destroy the Oslo peace process, intentionally targeting American students in Israel. The most famous of these is Elisa Flato of New Jersey, and other students like Matt Eisenfeld of Connecticut and Sarah Duker, also of New Jersey. Elisa Flato happened to be the first American student killed in an Iranian-sponsored bus bombing intended to destroy the Oslo peace process. You see Iran engaging in the same kinds of conducts even earlier, back into the 1980s. The last time the United States entered into this kind of agreement with the Iranians was 1981. That agreement is known as the Algiers Accords. It resolved and resulted in the release of what are people who are called the Tehran hostages. These are the American diplomats who were held captive in Iran for more than 400 days. And look at the result, again, through my optic. That agreement was executed in 1981. 31 months later, the Islamic Republic of Iran detonated the largest non-nuclear device ever exploded, resulting in the deaths of 241 U.S. servicemen in Beirut. Those service families are our clients. The $1.9 billion that we hold in our trust account, if this agreement does not interfere with that distribution, should be distributed to those families sometime this fall. You know, one country that we have completed the cycle for in this country, in this kind of litigation, is Libya. You know, Muammar Gaddafi engaged in a series of bombing campaigns against the United States and U.S. interests in the late 1980s, including the downing of Lockerbie and the LaBelle discotheque bombing, the LaBelle victims being our client. We separated collectively, and I'm including the work that other law firms did for Lockerbie, roughly $3 billion, something in excess of $3 billion in reparations from Mr. Gaddafi that were distributed to American victims. I dare say, in retrospect, if Mr. Gaddafi had known in the late 1980s that his bombing campaign was going to result in his having to cough up $3 billion to his American victims, he would have found some other way to be obstreperous. He would not have engaged in that bombing campaign. I think that the litigation that Congress has authorized American victims of state-sponsored terrorism to engage in serves a real national security purpose. There is no amount of money that will help compensate a family for the loss of their loved ones. The purpose of the litigation is deterrence. Thank you.
Thank you, Mr.
Apologize for running over.
And we'll have an opportunity in the Q&A to get further into that issue. Dr. Hannanen, you're now recognized for 5 minutes.
Thank you, Chairman Fitzpatrick, Ranking Member Lynch, and distinguished members of the task force, giving me this opportunity to address one of the most crucial issues in front of us today, which is the Iranian nuclear deal. In my testimony, I will focus on the verification aspects of the joint plan of action, but in my remarks, I am also mindful that the reference to the roadmap agreed between the IAEA and Iran, while it's publicly available, it has secret attachments which have not been available to me when I made my testimony and statement. Iran will retain a sizable nuclear program with its supporting nuclear infrastructure. In technical terms, Iran has not changed its nuclear cores. It will maintain substantial uranium enrichment capacity, and it's permitted to expand it after 10 years without having technical or economical needs to do so. In addition, the implementation of the additional protocol remains provisional until the time when the IAEA has reached a broader conclusion on the peaceful nature of Iran's nuclear program. This contradicts current IAEA practices. Such conclusions have only been drawn by the IAEA when the additional protocol is in force and ratified. This is not a matter easily to dismiss, as we need to be mindful of potential complications down the road should Iran seek to leverage, pull back, or dilute some of its obligation at some point of time under its provisional status. Verification in Iran involves implementation of safeguards agreement, additional protocol, additional transparency measures agreed by Iran, and the IAEA Iran roadmap. The sum of these parts is to block or at least to delay all pathways for Iran to get a bomb. Our assessment should focus on whether the verification provisions measure up to this goal and look at the JPOA's strengths, limitations, and challenges that it could face. We also need to ask ourselves what measures are in place that will prevent slippage or account for changing circumstances. In light of my previous testimonies, I only pick now some salient points. JCPOA has, from the verification point of view, strong points but also vulnerabilities. With additional access to Iran's nuclear facilities, introduction of modern monitoring tools to track nuclear material from cradle to grave, the IAEA will be able to detect and report in a timely manner any substantial diversion of declared nuclear material at declared facilities. The measures will also provide a high-level confidence that larger declared facilities, such as Natanz or the conversion facility in Isfahan, are not used to process undeclared nuclear materials. At the same time, we know that nuclear proliferation cases of the past have opted not to divert declared nuclear material but used undeclared nuclear material or undeclared facilities. To this end, JCPOA could have had included stronger provisions. The first one is the expanded declaration. As I have pointed in my previous testimonies, a complete declaration of all Iran's nuclear activities, including the past ones, for example, status of equipment and materials from dismantled installations, would be an important set for a credible baseline for monitoring and verification. This is particularly significant in Iran's nuclear program has been subject to several changes, has grown substantially since Iran stopped its provisional additional protocol implementation at the end of 2005. Access to undeclared and suspected sites. The JCPOA provides a dispute settlement mechanism should Iran refuse to cooperate or challenges the IAEA requests. There are, however, concerns that matter. One example is the mechanism by which information and evidence is provided that would compromise sources of intelligence and gives for Iran opportunity to take countermeasures to buy time and erase evidence. Timeliness of access also matters. The Comprehensive Safeguards Agreement in 1972, negotiated by IAEA Board of Governors, has a provision that IAEA Board can ask an access to nuclear installation if it believes that information gets compromised even during the arbitration process. Terms of the settlement time, 24 days, do not cover credibly all plausible scenarios. It is clear that the facility of sizable scale cannot be simply erased in 3 weeks without leaving traces. But likely scenarios involved here would be small scale, which would be critical to the weapon manufacturing process, such as manufacturing of uranium components for a nuclear weapon. A 24-day adjudicated timeline reduces detection probabilities exactly where the system is weakest, detecting undeclared facilities, materials, and keeping in mind the breakout times. Then I have some additional remarks with regard of the manufacturing of centrifuges, possible military dimensions, noting that IAEA has to provide a report by mid-December. I don't think that this will be a complete exhaustive report which will put the PND issue rest, since IAEA will not have time to do all the investigations according to its prevailing standards. And then I also draw your attention to a couple of other things. I think it would be very difficult to use American staff on these inspections in the next few years in Iran, which I see a deficiency because US citizens will bring extra skills which the IAEA otherwise doesn't have. And then on top of that, the IAEA has to, I think, issue a little bit more transparent reports.
Thank you.
Thank you.
Thank you, Dr. Hannan, for your testimony. Mr. Nephew, you're now recognized for 5 minutes.
Thank you, Chairman Fitzpatrick, Ranking Member Lynch, and other members of this task force for inviting me to speak today. It is an honor to speak to you in my first formal testimony before Congress. I would like to begin by extending my personal gratitude to the members of the U.S. negotiating team. Regardless of how one evaluates this deal, we are all most fortunate that this country produces dedicated diplomats, civil servants, and experts like those who worked on this deal. In my opinion, the deal that they negotiated is a very good one, especially compared to the most realistic alternatives, and any negative consequences can be managed. The deal reached satisfies the two most important U.S. national security objectives for Iran's nuclear program. One, lengthening the time that Iran would need to produce enough nuclear material for one nuclear weapon, and two, ensuring that any such attempt could be quickly detected. With respect to breakout time, the deal delivers, giving us years before we have a uranium breakout timeline shorter than a year. For plutonium, breakout can be measured in decades. Breakout is not the sole measure of a deal, but compared to the status quo, 2 to 3 months to break out for uranium, with 1 to 2 weapons worth of plutonium being produced per year at Iraq, we are far better off with the deal than without it. Further, with the transparency steps that Iran has accepted, both breakout and any attempt at a covert path will be easier to detect quickly. Some of these authorities will remain in effect for 20 to 25 years, while Iran's obligations to the IAEA under its standard treaties will continue in perpetuity. Even some skeptics may agree that within a 10 to 15-year band of time, the deal may work as designed, but that the sunsets present an irreconcilable problem. I disagree that this concern is worth killing the deal. The argument against sunset presupposes either that there is no point in time in which Iran could be trusted with a nuclear weapon or nuclear program, requiring regime change, or that negotiations could possibly have delivered a longer sunset. Having been in the room, I believe the length is as long as was achievable. And in any event, after key restrictions lapse, the United States is also free to declare that Iran's nuclear program remains a concern. Getting international support to do something about it will require effective diplomacy, but it is an option for a future president. The other major complaint is that it provides Iran with far too much sanctions relief, and that the practical effect of increasing trade with Iran will render snapback ineffective. First, it is a blunt reality that Iran was not going to accept major restrictions and invasive monitoring on the cheap. The administration did the right thing in leveraging sanctions relief for maximum early nuclear steps. Iran is now under every incentive to take the steps required of it as soon as possible, which the IAEA will verify before Iran gets an extra dollar. Of course, the sanctions relief provided by the United States does not equate with unilateral sanctions disarmament. The United States retains a number of sanctions authorities that will continue to exact consequences for Iranian violations of human rights and damage Iran's ability to engage in terrorism financing, though I personally believe fears about the extent of new Iranian spending in this regard are overblown, and according to the LA Times anyway, so does the CIA. But foremost of our tools remain secondary sanctions. The United States will still be able to pressure banks and companies into not doing business with the IRGC, the Quds Force, Qasem Soleimani, and Iran's military and missile forces. Even if the EU and UN remove some of these from their lists, these bad actors in Iran generally will find business stymied until they correct their own behavior in the eyes of the United States. This is both due to the direct risk of U.S. sanctions and the improvement in international banking practices since 9/11, a bipartisan effort begun under George Bush and continued under Barack Obama. The United States will also retain its ability to impose sanctions on those trading with Iran in conventional arms, as well as with respect to ballistic missiles, even after UN restrictions lapse. The United States can also trigger snapback of existing sanctions. Even just one JCPOA participant can trigger UNSC review and a vote on a UN Security Council resolution to continue with relief. The U.S. veto power in the UNSC gives us the ultimate free hand to reimpose these sanctions. This could come with political costs, and many skeptics point to these costs as likely meaning that no such snapback would ever be triggered. But international reaction to U.S. actions will always depend on the context. If the rationale for doing so is credible, then chances for success will always be higher. Iran, too, would have much to lose if snapback were to be triggered. The description of the deal as a Marshall Plan is an exaggeration, except that in Iran it needs the sort of domestic investment that it would provide due to damage from sanctions. Iran's leaders would therefore have to carefully evaluate the costs and benefits of any course of action that threatens the integrity of the nuclear deal. These costs will grow as Iran's economy grows. Some may see this as resilience, and I see it as Iran having more to lose. To conclude, though it is not a perfect deal, I believe that the nuclear deal reached by the United States, its P5+1 partners, and Iran meets our needs and preserves our future options. Like the Algiers Accord, it is necessary even if it will have consequences which must be managed. And I urge Congress to make the right choice and support this deal. Thank you.
We thank the witnesses for their testimony, and each of the members of the task force will be given 5 minutes now to question the witnesses. I'll recognize myself for 5 minutes, and I'll first ask Mr. Berman and Mr. Dubowitz if you could respond to the statement recently of National Security Advisor Susan Rice, who admitted, I guess, that some portion of the $150 billion that will accrue back to the Islamic Republic of Iran as part of the sanctions relief could be or would be spent to support international terrorism. So the question is to what extent you believe that these, and again, $150 billion is an estimate, but to what extent do you believe that any of these funds would be used to enhance the capabilities of their terrorist proxies, including Hezbollah, including the Houthi rebels that were mentioned earlier today in Yemen, to bring terror not just to the region, but to American citizens?
Thank you, sir. So I think the best way to illustrate the concerns that I have with regard to the fungible nature of the money that Iran will get is to hearken back to the experience that U.S. Congress and the U.S. government had with post-Soviet Russia in the 1990s. During that decade, we implemented a program called Cooperative Threat Reduction, colloquially known as NULUGR, to help the post-Soviet Russian Federation dismantle both conventional and unconventional weaponry, including ballistic missiles. The investment at the time, and I believe it was somewhere on the order of $600 million, was intended to widen the pie, so to speak, with regard to Russia's ability to execute dismantlement that it needed to do anyway. That was at least the rationale that was given. What was discovered belatedly was that the Russian government had allocated a certain percentage of its defense budget for this dismantlement, and an infusion of American cash was not sufficient to widen the pie. Rather, that money was used for other things, including a revival of the Russian bioweapons program in the late 1990s. I think the same concern is germane here. The sanctions relief, and the scope is indeed enormous. It's certainly not a Marshall Plan of the 1940s, which was $800 billion for all of Europe, but $100 billion for one individual country is still an awfully large sum of money. There is that concern that that money will, even if it's spent overwhelmingly on domestic affairs, will free up other dollars that will be spent on terror, perhaps significantly so.
Mr. Berman, do you concur?
Mr. Dubowitz, yeah, I do
Dubowitz, I'm sorry.
concur with Mr. Berman. I think we also need to talk about economic relief. It's much more than $100 billion. It's much more than $150 billion. We're talking about economic relief that will allow Iran to sell 2.5 million barrels a day, which will increase its revenues about $15 to $20 billion a year, opens up its auto sector, which represent about 10% of the GDP of Iran, its petrochemical sector. We're talking about hundreds and hundreds of billions of dollars over time. Now, I agree with Mr. Berman, and I agree with Mr. Nephew. I don't think Iran is going to spend all of its money on terrorism. Iran will spend some of its money on terrorism, and a small percentage of hundreds and hundreds of billions of dollars means that Iran can keep Bashar Assad in power for more time. It cost Iran about $6 billion a year, according to the U.S. Special Envoy on Syria, to keep Bashar Assad in power, not to mention the hundreds of millions of dollars available for Hezbollah and other terrorist organizations. But picking up on a point that Mr. Nephew made, the problem is Iran is also going to spend its money on its economy, and not just on growth and diminishing unemployment, but on economic resiliency. See, the Iranians learned from 2012, 2013, when we were hitting them with asymmetric shocks to their economy that plunged them into a severe recession. They don't want to be in a situation again where their economy is fragile. So they will keep substantial foreign exchange reserves in place and build up the kind of resilience they need down the line so that when we try to snap back our sanctions, it will not have the kind of asymmetric impact that it had on Iran at that time. Economic resiliency is their rainy day fund. That's what they're thinking of down the line when they have an industrial-sized nuclear program if near zero breakout, and we try to use economic leverage in the future to peacefully enforce the deal. I believe we will diminish our peaceful enforcement of this deal. We will leave the future president with two options: accept an Iranian nuclear weapon or use military force to forestall that possibility, which is why this deal makes the war more likely, and when that war comes, Iran will be stronger and the consequences will be more severe.
Thank you. Mr. Perlis, briefly, if you can, the Beirut barracks bombing, 1983. Right. Many of those Marines were residents of Commonwealth of Pennsylvania, some of their families, constituents of mine. They have an open judgment against Iran for their connection. Correct. How do we bring closure to families like those?
Two-track process, sir. First, we have this $1.9 billion of illicit Iranian funds that we captured in New York. That money is almost ready for distribution. The Supreme Court has solicited the views of the Solicitor General of the United States with respect to the underlying statute that Congress passed to help us get at those funds. The statute is facially constitutional. If the committee could assure that the Solicitor General promptly issues its statement of interest to the court affirming the constitutionality of that statute, we should be able to proceed with releasing those funds this fall.
Thank you.
Second issue, and one that is far more serious from its implications, are what are referred to as movement of funds by book entry. That process can simply be described as if you have $1 billion in a bank account in New York, and one day it's owned by a commercial company, and the next day that $1 billion belongs to the Islamic Republic of Iran, but instead of moving money by SWIFT back and forth, you simply keep track of who's earning the benefit of that money by a book entry sitting in a bank in Luxembourg. You are able to entirely avoid sanctions.
Mr. Perlis, I'm out of time. Maybe we can get back to this in the second round of questioning if that's possible, but I want to recognize the ranking member of the task force, Mr. Lynch, for 5 minutes.
Thank you, Mr. Chairman, and again, thank you to all of our witnesses. Professor Heinonen, you've actually, in the past, been an IAEA inspector, is that correct?
That's true.
Okay. And from our earlier conversations, and again, thank you for your willingness to help the committee, you indicated that you've been on the ground in Iran previously with inspection responsibilities, is that correct?
Yes, true.
Okay. Can you tell me a little about that? How long were you there in Iran?
Actually, I have not never counted the number of days I spent.
Okay.
But I went the first time actually in 1986, and it was a very different year.
When's the last time you were in Iran?
2009.
Okay. So you've had a chance to see how the inspection protocols work, and I guess to try to simplify it for people, on a scale of 1 to 10, let's say 1 is that the agreement is worthless, okay? And 10 means the agreement provides absolute security. Where along the spectrum, you've had a chance to read this agreement now, and sift through this and try to figure out what the inspection protocols and monitoring would provide. Where along that spectrum do you think you would, on a scale of 1 to 10, what's the value of this agreement in your estimation? I'm trying to simplify, I'm sorry, but it's the best we can do.
Yeah, it's a little bit difficult to give the rating yet because there are a few aspects of this agreement which I don't know, like, what is the real agreement between Iran and IAEA on this possible military dimension?
The PDM?
PDM, so that's a little bit unknown here. And this is then to do with the setting of the baseline for the monitoring. And then there are certain uncertainties also, I think still in the text with regard of the past activities on Iran, and that's why I urge that baseline there.
Right.
If you have a poor baseline, then your verification system will get compromised. But with
Providing we
this
get that.
information available today, I would rate perhaps 1 to 10, maybe 7, 8.
Okay, 7
Not
or 8.
high of.
Okay, I appreciate that. Mr. Nephew, I noticed that in the agreement that there are carve-outs here. If you look at the sanctions that are provided with relief, they're almost exclusively regarding nuclear activity. There are sanctions that were put in place because of past nuclear activity and nuclear research, uranium enrichment, things like that Congress and the UN and the EU and the President of the United States have put in because of nuclear activity. I don't see any lifting of sanctions regarding terrorism or funding. And look, no question about it, Iran has funded Hezbollah, has funded, not Al-Qaeda, they're Shia, they're Sunni rather, but has funded Hamas, has funded Islamic Jihad and others. So I'm not coding that over in any sense. But the agreement is focused on the nuclear activity and not on the so-called terrorist funding activity. Is that correct?
Yes, sir, that's correct.
Is there anything to stop us from maintaining I had a chance to talk to Mr. Zubik over at Treasury, who sort of rides herd on all of these financial sanctions, and he tells me that they're going to stay in place. Is that your understanding?
Yes, sir, that's my understanding.
Okay. And would anything in this agreement stop us from, if we saw money going to, from the central bank to any of these groups, we could put sanctions in place against the Central Bank of Iran if we saw further violations of terrorist financing provisions?
Yes, sir, that's a possibility. I think the big issue at that point will be what the Iranian response would be to that. I mean, they have the ability to say that they think that that kind of sanction would violate the terms of the deal because it would imperil the rest of their relief. But we have not ceded any ability whatsoever to impose sanctions with respect to our terrorism, human rights, or other related authorities that are outside of the nuclear arena.
Okay, thank you. I've got 6 seconds left. I'll just yield back my time. Thank you, Mr. Chairman.
Now recognize the Vice Chairman, Mr. Pittenger, for 5 minutes.
Thank you, Mr. Chairman. Mr. Pearls, you stated in your testimony that the representation of victims for you and your legal group has enabled $1.9 billion.
Yes, sir.
Given that, you said that would be a deterrent toward future actions, considering Gaddafi and the bombings of Lockerbie and LaBelle, that perhaps he would be thinking about future efforts. With that in mind, with this agreement, it appears what we've done on these cases with these victims, it would basically wipe out this agreement, resulting that these funds would no longer be accessible. Is that a concern to you, and that they would not be able to receive the judgments repatriated back to them and be accessible?
Yeah. It's a serious concern to us. As I said to Mr. Fitzpatrick, it would be very helpful if the committee could assure that speaking again for the Beirut Marine Barracks bombing families, that $1.9 billion remained available as an asset. those funds are no longer with the Islamic Republic of Iran.
The future funds won't be accessible if, in the case of...
Future funds could be a very serious problem. There are no future funds currently in the United States. Were we to go out and try and reach funds outside the United States, and we are trying to do that currently in Italy, I can tell you that we have not received a warm reception overseas from governments that like to trade with the Iranians. In our enforcement activities for the Flato, Eisenfeld, and Duker case in Italy, where I suspect a lot of this $100 billion will go as they're Iran's largest trading partner in the EU, the Italian Foreign Ministry has formally entered our proceeding against the Iranians in objection to our domestication of the Flato, Eisenfeld, and Duker terror victim judgments in Italy. If the Italian courts abide by the request of their foreign ministry, essentially these judgments become non-entities in Italy and probably the rest of the European Union.
Thank you for that. Mr. Dubowitz and Mr. Berman, we have repatriated back to Iran $700 million a month for the last 16 months, $12 billion. We certainly see their footprint throughout the Middle East, in Yemen and Syria and Iraq. Now they're going to have access to substantially more money than that. It will be an enormous challenge for FATF and our Treasury, working with other governments, to track these funds as they go through the financial system, through the 47 financial institutions there in Iran and their capacity through money laundering. What advice, or where do you think we should go? Given that this could very well be the case, what do you recommend we could do to enhance the role encourage the role of FATF, the 34 nations that work together, and the role of Treasury? We're going to have a lot more money accessible for terrorism financing.
So, Congressman, my recommendation would be that Treasury should submit to House Financial Services a Iran sanctions rehabilitation program with benchmarks that the financial institutions and the Central Bank of Iran have to meet before they are allowed back onto SWIFT. Because here's the problem that Mr. Nephew is not telling you about. The problem is the Central Bank of Iran is going to go back onto SWIFT. So are dozens of Iranian banks. It will be virtually impossible for us to de-SWIFT those banks again. Because the head of VTB Bank in Russia, when the British were talking about de-SWIFTing Russian banks, called that an act of war. The Iranians will call that an act of economic war. And what they'll do is they'll use their nuclear snapback in this agreement to claim that the reimposition of those sanctions and the de-SWIFTing of the Central Bank of Iran and other banks constitutes a violation of this agreement. Now, we might say, well, that's not true. It's non-nuclear. It's terrorism. We have the absolute right to do this. But the problem is that the Iranians will then intimidate the Europeans, and they'll say that we will walk away from the agreement, we'll engage in nuclear escalation because the de-SWIFTing of our banks is an act of war. We will never get the Iranian banks off SWIFT again. It took an act of God to get them off in the first place. We'll never get them off again. Now, once they're plugged back into the formal financial system, and by the way, we have not required them to actually rehabilitate. There's no indication that they're no longer engaged in illicit financial activities. And by the way, it wasn't just nuclear, it was ballistic missiles, it was terror financing, it was money laundering, it was sanctions evasion. That's the reason the central bank got designated in the first place, designated by Treasury. And a 311 finding. It wasn't just nuclear, Ranking Member Lynch, it was actually a range of illicit financial activities that constituted the basis for that designation in the first place. And so what we've done essentially is we've swept all of that away for a nuclear deal, and we're allowing all of these banks back onto SWIFT to plug back in the formal financial system without actually having any indication that they've been rehabilitated. So I would, if I were House Financial Services, I would require Undersecretary Zubin in the U.S. Treasury Department to present a rehabilitation plan to you with specific benchmarks and to demonstrate to you on a timely basis over time that these banks are now rehabilitated banks. And only then should they be de-designated and put back into SWIFT, because once they're on SWIFT, we're not getting them off SWIFT ever again.
Gentleman's time has expired. The gentleman from California, Mr. Sherman, is recognized for 5 minutes.
Oh, thank you. This deal has the good, the bad, and the ugly.
The good is the good and the bad happen the first year. We get rid of the stockpiles, we decommission two-thirds of the centrifuges. The bad, you witnesses have already commented on, they get their hands on tens of billions of dollars. The ugly is next decade, when they can have such an enormous nuclear program that, in the words of the president, their breakout time would be basically zero. So the question at a minimum is, how do we put ourselves in a position where we force a renegotiation of this deal before we get to the ugly? There's a natural tendency and the witness has done this, I tend to do it, is to grade the deal, as if we're pundits trying to say whether the president did a good job or not. And that's a wonderful use of time, but we don't have a time machine to go back to June 2015. And pundits get to do that, but we have to decide how to vote. We got 3 possible votes coming up. One is a vote to approve the deal. That's got 0.0% chance of passing. If it did pass, it might morally bind future administrations to the deal. So we're not going to do that. The deal is an executive agreement, which is below an executive legislative agreement, which is below a real treaty. So this is the weakest possible exchange of notes among the executive branch. And if, God forbid, we were to vote to approve this, and maybe somebody could claim it was an executive legislative agreement, but we won't, and it isn't. But the real issue before us is whether we vote to disapprove and whether we override. And one of the reasons not to vote to disapprove is because we'll probably fail to override. And then we're going to be in a circumstance where we're telling the world Congress has not ratified or endorsed the agreement, and the proponents are showing a picture of themselves celebrating our failure to override the veto. So the last vote will be a victory for the 34% or the 40% who vote not to override. That's confusing to the world, so I'm hoping that instead we just vote on a resolution to approve and vote it down. But if we do override, that has real legal binding effects. But we were in the classified hearings, and now I'm here trying to figure out what those effects would be. Legally, what it does is it restores the sanctions and deprives the president of his authority to waive the sanctions. Those sanctions are not sanctions on Iran. Those are sanctions on British and French and Japanese and Indian banks. Those are sanctions against Italian and Russian and Chinese oil companies. It's easy to say we want to sanction Iran. Start asking people, do you want to sanction French banks? So the question is, how will other countries react if we try to sanction their businesses for doing something our president says is a reasonable thing to do, which is do business with Iran as long as they're following the agreement that Congress may very well repudiate. So, Mr. Berman, how are the French, the Italians, the Japanese going to react if Congress wants to punish their banks and cut them off from the most important financial banking sector in the world because those banks dare to participate in transactions which the President of the United States says are legitimate and, oh, by the way, are profitable for the home country?
Well, sir, in a word, not well. And I know you you led me to that answer, but if you remember, earlier this year I had the privilege...
Could they kowtow? Politically, could they kowtow? Could they say, look, we're announcing that we're going to prevent our banks from doing these transactions, prevent our companies from doing these transactions.
Yes.
The President of the United States thinks they're reasonable. We think they're reasonable. We think they're profitable. But Congress is so powerful that we're going to prohibit our companies from engaging in reasonable and profitable businesses.
So, sir,
could an Indian, could Modi do that? Could Abiy do that? Politically, even if they wanted to, could they go to their people and say we're kowtowing to Congress?
So I think Mr. Dubowitz will have some input as well, but my amateurish interpretation of this is absolutely they could. provided there is political will to actually enforce those sanctions and enforce those measures. Because, as we've discussed before, one of the bipartisan failings of Iran sanctions up until this point is that while there are the legislative means to sanction these banks for engaging in this commercial activity with Iran, what we've been lacking on both sides of the political aisle has been the political will to truly enforce.
If I can just sneak in one comment, we were just at the classified briefing, and a non-classified non-answer was I asked the administration whether they would follow the law and under those circumstances punish those banks, and the answer was deafening non-answer. So it's by no means sure that the president would impose those sanctions, let alone that our trading partners would adhere to them and would accede to them, and I yield back.
Gentleman's time has expired. The gentleman from Florida, Mr. Ross, is recognized for 5 minutes.
Thank you, Mr. Chairman, and I want to thank the witnesses for being here. Mr. Berman, you spoke in your opening statements about the use of funds to be funneled as they have been for such things as building Iranian regime contacts. For example, I think you said that they put $6 billion annually into Bashar Assad's coffers, and that we are continuing to fund, or they're continuing to fund Hezbollah, continuing to fund Hamas, the Houthis. We had some witnesses testify before this task force some time ago that essentially stated that Iran was the central bank of terrorism. And so what we are now about ready to do, if this deal is effectuated, is to allow for an increase anywhere from $100 to $100 billion of frozen assets, accounts, and then to channel this money through the same infrastructure that's been there to fund state terrorism. Now, it seems to me that we have allowed, or at least the premise of this negotiation has been, let us not have an Iranian nuclear weapon capability, but let us do so at the expense of expanding international and global terrorism. And to that end, I ask, what are we to expect? Are we to expect that now those missiles that were funneled down into Gaza are going to be more sophisticated? What are we going to expect with regard to the missile defense system that now will be sold from Russia to Iran? Are we here just basically saying that we have licensed the management of nuclear capabilities in Iran totally at the expense of expanding terrorism throughout this world?
Well, sir, I think you hit upon what I believe is a crucial point, which is that when we begin to looking at this agreement, one of the, I believe, most sober ways to approach it would be to look at the consequences and whether or not the United States has the political, economic, and strategic tools to manage the consequences that are likely to flow from it. Obviously, increased funds allocated to terrorist proxies of the Islamic Republic is a tremendous concern.
And it's going to happen, as a matter of fact. I mean, let's just look at history. It's happened. And now let's look at history with our relationship with Iran. Okay, the only thing that we have to rely on to make sure that this deal is effectuated as it is written, quite frankly, is the trust of Iran. And so let's look at the history with Iran. Let's see. Since 1979, on every November 4th, they proclaim Death to America Day. Just recently, within the last year, they've put a mock battleship out in the Persian Gulf and had that attacked and sank in the name of destroying the United States. So essentially, we've negotiated a deal that says that we're going to have to trust Iran, and yet we're going to have to trust them through a third party. So have we managed our consequences to this point? And if not, what in history has given us any indication that this was a deal that we should have negotiated?
I don't believe we have, and in my opening remarks I made the point that although the premise that the White House has put forward for the deal is transactional in nature, that this is limited, it's limited to the Iranian nuclear program, the way we've gone about negotiating this and the things that we've put on the table, including massive sanctions relief, as a result.
And the sanctions have worked. The sanctions have worked.
They have, but the ability to rehabilitate the Iranian economy and provide additional aid to terrorist proxies of the Islamic Republic is a function of the fact that we are looking at this deal privately aspirationally, the idea that Iran will turn over a new ideological leaf as a result of these
And
negotiations.
if there is a violation by Iran, the realistic expectation of snapback sanctions is not realistic at all, is it?
I think there are many technical reasons to be very skeptical of snapback, but maybe the most important is the fact that, as former Secretary of State Henry Kissinger has written about in several books, as you become deeply enmeshed in negotiations, such as the ones that we're engaged in today, you become a vested stakeholder. And bad consequences are actually
You do it for the sake of having a deal, not for the sake of the substance of the deal that would have benefited you had you stayed to your principles at the outset. Mr. Peros, one real quickly. What did the administration use to determine what were considered sanctions for nuclear violations and terrorist violations? If you have, I've just run out of time, I think.
Simple answer to your question, I remain totally befuddled. I have no idea.
I agree with you. Thank you. I yield back.
Gentleman from Texas, Mr. Green is recognized for 5 minutes.
Thank you, Mr. Chairman, and I thank the ranking member as well. You never know who's tuned into these hearings, and for this reason, if by chance a member, a family member of someone who's being held hostage is tuned in, I would like to make it very clear that we are still working to get them returned, those who are being held hostage. And while we talk about transactions and all of the various ramifications of a deal, we have not forgotten them. And that's, I think, important for us to say. Mr. Nephew, I noticed that you were making notes, and your name has been mentioned on more than one occasion, and you have not had an opportunity to respond. Do you have something that you would like to say in response to some of the things that have been said and directed toward you?
Thank you, sir, for the opportunity. I would say just a couple of things to preserve your time. First off, I think there are some distinctions about the way in which sanctions were applied against the Central Bank of Iran that are relevant here. The United States did not impose a designation on the Central Bank of Iran in the traditional sense, in part because we recognized the dramatic economic implications that could result from that. Instead, we took sanctions decisions that were intended to clamp off their ability to get access to oil revenues, and it's a very unique way of doing business. We also imposed sanctions that dealt with basically stigmatizing the Iranian financial system for terrorism, money laundering related reasons. So far as I'm aware, none of those implications are lifted as a result of this deal. Now, there are people out there who will still sell oil or buy oil from Iran and transact with the Central Bank of Iran, but we have not given a green light to believe that the Central Bank of Iran is a good institution or institution that's not involved with respect to terrorism or money laundering or any of these other things that they're involved with. The reality is, though, if you're going to get a nuclear deal with Iran, they are not going to do it without real sanctions relief, without real economic sanctions relief. And the decision that was made by the administration, and again, I think it was a good decision, was that getting 10 to 15 years of real distance from Iranian nuclear weapons breakout was worth dealing with a future consequence of Iranian economic revival. I should also note, too, on this issue of 100 to 150 billion, I think there's an impression that it's a savings bank that was opened up for the Iranians, and that was, it's money that's just pouring in that we can't wait to give back to the Iranians. We should bear in mind that this is Iranian money that we have been restricting from them that they have not been able to use. It's for this reason that they had the economic downturn that Secretary Liu spoke about earlier. So I think the bottom line is the Iranians do have a lot of things they need to do with this money. It is not a gift from the U.S. taxpayers, and it's not manna from heaven for them.
Mr. Nephew, you have some knowledge of this. Were you associated in any way with these negotiations?
Yes, sir. I was the lead sanctions negotiator starting in August of 2013 until I left the government in December of 2014.
And is it your opinion that we can or cannot reopen the negotiations?
Sir, I do not believe that we can reopen these negotiations. I believe that to do so or to attempt to do so would cripple us in those negotiations, particularly dealing with countries like Russia and China, not even to mention our European partners.
I believe there are others who have opinions that differ, so I'd like to give some equal time Let's see, Mr. Dubowitz, you have an opinion that varies from this, I believe.
Well, thank you, Congressman. I think there's an alternative because President Obama always said there was an alternative. He said that no deal was better than a bad deal. And the president is a responsible commander-in-chief and a responsible executive, and he went into these negotiations knowing that he had an alternative to this deal. And I believe that we agree with that, with the president. He has an alternative. The alternative is to use course of American power, including U.S. secondary sanctions, in the context of the U.S. Congress asking this president to negotiate a better deal, particularly around snapbacks and sunset provisions. Now, if the president doesn't believe in the power of U.S. secondary sanctions, if his argument is that if you vote down this deal, the sanctions regime will crumble, then unfortunately there is no power in the economic snapback, because the economic snapback actually depends on the power of U.S. secondary sanctions to send a message of fear to the marketplace so that financial institutions and energy companies at 7, 8, 9, 10 years, when they've sunk in hundreds of billions of dollars back into the Iranian economy, by the way, contracts that are grandfathered, that they will respond by moving out of the Iranian economy. So the president can't have it both ways. Either there was an alternative to this deal, in which case he was a responsible negotiator who went in with the best alternative to negotiated agreement, or there's no alternative to this agreement, in which case he negotiated with the Iranians without an alternative. Either U.S. secondary sanctions are powerful, in which case, Congressman Sherman, they will survive if Congress votes no, because ultimately they send a message to companies and financial institutions based on risk and reputation who will not want to go back into Iran given the power of U.S. secondary sanctions, or they're not powerful, in which case we're going to have a really significant problem on our hands down the line when Iran has an industrial-sized nuclear program with near-zero breakout, significant economic resilience, and the banks are all back on SWIFT, and we try to go back in order to try and impose sanctions.
Gentleman's time has expired. The
Thank you, Mr.
gentlelady
Chairman.
from Missouri, Ms. Wagner, is recognized for 5 minutes.
Thank you, Mr. Chairman. I want to thank the panel for being here today. I have to say that I find all of your comments much more enlightening and informational than the classified briefing that we just attended by 1,000-fold. It is an absolute fact that the cumulative effect of Western sanctions on Iran is the reason that Iran finally came to the negotiating table. These sanctions have led to a 15 to 20% decline in Iran's GDP since 2010 and have driven down Iran's crude oil sales by some 60%. Yet, while Iran's economy has significantly declined, their investment in terrorism groups and in regional, I'll say, proxy militias engaged in conflict has remained the same, if not increased. Iran has continued to support, as we've heard from everyone, both sides of the aisle, Hezbollah, Hamas. They've involved themselves in conflicts in Egypt, Syria, Yemen, Iraq, and have successfully been promoting further instability throughout the region. It would seem logical to say that if Iran could find the resources to support terrorism and regional turmoil while under the intense pressures of economic sanctions, as they have been, they will continue to do so under this deal, if not to a greater extent due to their increased access to financial resources. In fact, it was National Security Advisor Susan Rice that admitted that some of that $150 billion that Iran will receive will be spent to support international terrorism. I don't think anybody disagrees with that. However, there are some in the administration that have indicated that they believe Iran will steer this additional funding into its own economy. Mr. Dubowitz, how likely is it that funding will be steered towards military proxy groups engaged in destabilizing conflicts in the Middle East, including Iraq?
Congresswoman, it's very likely that they will spend money on terrorism and supporting Assad. It's also very likely that they'll spend money on economic resiliency. And I think, unfortunately, the conversation, the debate is getting lost because economic resiliency, from our perspective, is a very, very bad thing. Because economic resiliency means that Iran can fortify its economic defenses against future economic pressure. Now, Dr. Heinen has spoken about verification and inspection, but verification and inspection is only as good as enforcement, and the IAEA does not enforce. The United States of America enforces. So it will be the United States of America that will enforce this deal against Iranian stonewalling and cheating. And if we have lost our ability to use peaceful economic leverage to enforce this deal, the Iranians will therefore cheat incrementally, daring us to respond to them using military force. No president will use military force against incremental cheating, and Iran will have the ability not just to break out or sneak out to a bomb, but to inch out to a bomb.
Well, and we will only have, the U.S. will only have secondhand knowledge of Iranian facilities, to be perfectly honest, as we will not and cannot be directly involved in the process of monitoring or of verification. I wish I had an hour to visit with each and every one of you. I understand Iran's status as a state sponsor of terrorism was not part of this deal. Do you believe, Mr. Berman, that Iran will seek to be removed from the state-sponsored terrorism list?
Ma'am, I don't think necessarily that's a proximate goal, although it's certainly something that, provided the political winds shift in that direction, may be raised with regard to Iran. Where I think we enter the zone of danger with regard to increased Iranian sponsorship of terrorism as a result of the JCPOA is precisely the fact that under the current structure of the deal, and under the current mechanisms in the hands of the U.S. Treasury Department, the Financial Action Task Force, and other bodies that are tasked with overseeing this, we simply don't have mechanisms that allow us to provide responses that are short of walking away from the table. In other words, there's no scalable responses to Iranian cheating. And as Mr. Dubowitz said, Iran is far more likely to inch out of its obligations with regard to the deal than to break out and make a sprint for the bomb. And as a result, what we have is a scale problem. Currently, we don't have the ability, short of abandoning the process altogether, to exact tactical punishments from the Iranians for instances of malfeasance, including additional funding for terrorism.
Mr. Berman, as I'm running out of time, and let me just say this, Mr. Dubowitz, I am very interested in your discussion about the rehab plan and the Central Bank of Iran. I spent 4 years as United States ambassador to Luxembourg from 2005 to 2009. I am very, very familiar with the Central Bank of Iran, and I would consider one of the most important things that I've ever done in my entire life was to stop terrorist financing from being laundered and sent through the Grand Duchy of Luxembourg. So I'm very interested in your thoughts on SWIFT and the rehab plan, and I would love to pursue that with you in the future. I'm sorry I'm over my time. I yield back.
Gentlelady's time has expired. Mr. Himes of Connecticut is recognized for 5 minutes. With advice to the members of the task force, we're in the middle of a vote, so at the conclusion of Mr. Himes' questioning, we'll go into recess. We'll reconvene at approximately 6:35 for the remainder of the questions. Mr. Himes?
Thank you, Mr. Chairman. This is clearly a challenging decision for the Congress. It is the opposite of a black and white decision. If there's anybody who is under the misapprehension that this is an easy call, I think that speaks more to their credibility and bona fides than it speaks to their understanding of what is a very, very complicated thing. And to illustrate that, this hearing, the undercurrent of this hearing is how shocked we are to learn that as a result of this deal, Iran may get some money. There's a little controversy over how much money, the figure of 100 to 150 billion keeps being bandied about. The Treasury Secretary, and I'll let those of you who are saying 100 to 150 billion work this out with the Treasury Secretary, he estimates the money at $56 billion. Setting that aside, we're shocked that this terrorist regime is going to get money. Folks, this was the deal. We voted for the sanctions for the express purpose of taking away the money to force them to the table to negotiate the deal. Now, we may agree that the deal is good or bad, but to negotiate the deal whereby they would get that money back. And now we are shocked to learn that this bad regime is getting the money back. Now, bad regime, we get it. We know that. I'm on the Intelligence Committee. I see that day in and day out. You do these deals with bad regimes. In the 70s and the 80s, we did these deals, these similar nuclear deals with China and with Russia at a time where I would dare say they were both committing probably things that would qualify as crimes against humanity. But we do these deals not with our friends, but with our enemies. And context is important here, because we find ourselves with a deal. It turns out when you negotiate with Persians, you don't get everything you want. You got to deal with some things that make you uncomfortable. But what about the history of deals? Yes, there was the Algiers Agreement, whereby we freed some hostages. We haven't mentioned, by the way, the deal that was struck by the Reagan administration in 1985, 2 years after the Marine bombing killed over 200 Marines, whereby the Reagan administration provided conventional arms to Iran so that hostages would be released, so that U.S. law could be violated to fund the Contras, violating the Boland Amendment. George W. Bush tried to strike a deal at which there would be no enrichment. That deal fell apart, and we found ourselves with 19,000 spinning centrifuges. So the question I have, and the idea is that context is important, this isn't a great deal. You don't get a great deal in situations like this. I personally believe that the idea that we can just shut it all down, and remember, the president's coming under a lot of criticism here. The Russians, the Chinese, the UK, France, the EU, this was a P5+1 deal. My question is, and I haven't gotten a good answer on this, I have 2 minutes left. If we unilaterally say no to something that the world negotiated, that the Security Council has endorsed, that the EU has endorsed, what scenario results in us being in a better position than the position of having 15 years, and I understand they may cheat, but 15 years in which we have some confidence, unless they cheat, that they're not building a bomb? What happens that puts us into a better place than we are in if we accept this deal? I just open that up for a scenario that is better than accepting the deal.
Well, Congressman, first of all, this is not a 15-year deal, and it's not even a 10-year deal. You have to look at this deal not through the prism of nuclear physics. You have to look at this deal through the prism of Iranian economic, conventional, and military power. The Iranians have negotiated an agreement that, in terms of their deal structure, is front-loaded.
But you do agree, this is a nuclear deal. I get that they spent...
No, it's not a nuclear deal. Because we're lifting the arms embargo, we're lifting ballistic missile restrictions, so it's not just a nuclear deal.
Got it. But from the standpoint of developing a nuclear weapon, the centrifuge and the enriched uranium is in fact a 10 to 15... Unless they cheat, there's a 10 to 15-year period in which there's high confidence and high visibility that they're not building a bomb, right?
Well, actually, I don't think that's true at all. In fact, by year 8.5, they begin to develop advanced centrifuges. By year 10, they begin to enrich at the Natanz facility and install a limited number of centrifuges.
They can't enrich above 3.67, right?
So what they've done is they've phased this so that they can start introducing on an industrial scale advanced centrifuges. So right at year 15, they can actually enrich not to 3.67%, not to 20%, but to 60%. Because they will use that as justification that they're going to have a nuclear-powered Navy. So what the Iranians have done is they front-loaded the sanctions relief. They're getting the arms embargo lifted, the ballistic missile restrictions lifted. They're fortifying their regional presence. They're getting back into the formal financial system. And they've negotiated themselves a patient pathway to a bomb. So when that pathway actually comes, because we're not cutting off the pathways, we're delaying them, and then we're expanding them. When it finally comes, Iran will be much stronger economically, from a nuclear perspective, from a ballistic missile perspective, regionally, and with respect to terror financing and its proxies. So when it comes, Congressman, the problem is we are in a worse situation, because we now have a hardened regime with an industrial-sized nuclear program at near zero breakout, which means it's undetectable breakout, and they have multiple enrichment facilities buried in a mountain looking like Fordo. And then we have a problem on our hands. Now, the problem on our hands at that point is we have no other peaceful way to stop them, which is why this deal, in my opinion, is going to lead to war. And it will make war more likely. The other thing that I want to take issue with is we didn't put these sanctions in place to respond to Iran's nuclear program. The U.S. Treasury Department over 2 administrations said these were conduct-based sanctions. Your task force is about illicit financial conduct. Your task force should be very concerned that we are lifting sanctions on the Central Bank of Iran and letting all these banks back onto SWIFT, despite the fact none of these banks have been rehabilitated from an illicit financial perspective. That's a concern.
Expired. Appreciate it.
No.
Ask unanimous consent. I know we said we're going to go to recess. The House Foreign Affairs Committee Chairman is here, Mr. Royce, who would like to be recognized without objection.
Thank you, Chairman.
If there's no objection, Mr. Royce is recognized.
To get a clear sense of the consequences of Iran's support for terrorism, I just wanted to give the committee one horrific example. In January 20th of 2007, a convoy of SUVs cleared several checkpoints to reach a government compound that included our American security team. Once inside the base, the vehicle occupants who were wearing U.S. uniforms provide to them, and speaking English, by the way, fatally shot one soldier. They kidnapped 4 other U.S. soldiers. With U.S. and Iraqi forces in pursuit, these Iranian-supported militias executed our 4 soldiers in cold blood. One was the father of 2 small children from Southern California. Hezbollah, the Quds Force, and their Shia militia proxies were behind this attack. And shortly after, U.S. forces apprehended Ali Musa Dakduk, senior Hezbollah operative who, together with the IRGC, masterminded that particular attack. Unfortunately, the current administration did not retain custody of this individual, and an Iraqi court released him in 2012. And the point is this: there are many amongst the IRGC who have had to operate under the restrictions that sanctions have placed on them, and that sanctions are being lifted. But they remain committed to harming the U.S. And I don't take their chance of death to America as an idle threat. As part of the nuclear agreement, the Obama administration is committed to bringing the Central Bank of Iran and a number of major Iranian financial institutions back into the global financial system, a financial system that's much different today than the one that Iran knew in 2012. Between the increase of cryptocurrencies and the increase in the use of non-banks, our vulnerabilities to Iran's terror finance apparatus have increased. And our legislative and regulatory structures have not been adjusted for some time, and my concern is that their effectiveness is beginning to decline. So my question to Mr. Dubowitz and to Steve, to Mr. Perlis as well, is what specific measures would you recommend Congress take to effectively address these vulnerabilities? And I'll add one other question to you, Steve. Clearstream, a known money launderer for Iran, is still moving Iranian money out of New York to Luxembourg through an illegal book entry system to keep the Beirut Marines, the families of those Marines, from enforcing their judgment. In your experience, what is OFAC doing about this kind of book entry-based laundering for Iran? If you don't have time to finish this, by the way, here we could have, for the record, but Mr. Dubowitz and Mr. Perlis, if you'd like to give it a shot.
Thank you, Chairman Royce. You're exactly right. Europe is going to become a Revolutionary Guard's economic free zone. The Europeans are lifting sanctions on the Revolutionary Guards and the Quds Force. Iran's Revolutionary Guards and Quds Force can now operate much more freely in Europe. What would I do? First, Congress should require that the IRGC be designated as a foreign terrorist organization. It should also be designated under Executive Order 13224 for directing and supporting international terrorism. The IRGC is only designated for proliferation purposes under U.S. law. Second, as I mentioned earlier, Chairman Royce, this task force and Congress should require Under Secretary Adam Zubin to present a rehabilitation program to you with specific benchmarks to explain how these financial institutions, including the CBI, will be rehabilitated, and to demonstrate to you that they're no longer engaged in a full range of illicit financing.
Thank you, Mark. Steve?
Thank you, sir. Let me start by saying that the Karbala attack that you referred to in Iraq is one of my cases, and I promise you, sir, I will see that case through to the end. I take the Department of Defense issued POW medals to each of these servicemen, and of course, that were presented to their families. No nation, let alone Iran, gets to take a U.S. serviceman into POW status and extrajudicially execute them. I promise you, sir, I will see that case through to the end. It is, the conduct there is patently offensive by any standard.
And I think we better get the rest of the answer for the record in writing. And Mr. Chairman, I think you and I had better make tracks to that vote right now. Thank you.
Thank you, sir.
The task force is in recess. We appreciate the perseverance of the witnesses. We'll be back approximately 6:35. Thank you. Go ahead.
Yeah, I mean,
Okay.
I think Lynch is coming back.
This meeting is reconvened and the hearing called to order. We appreciate the perseverance of the witnesses and your testimony here today. Mr. Rothfuss of Pennsylvania is recognized for 5 minutes of questions.
Thank you, Mr. Chairman. Again, thank the panel for sticking with us through that series of votes, and apologize for your inconvenience, but thank you for being here. I want to talk a little bit about the idea of the intermingling of the types of sanctions, nuclear, non-nuclear, ones that were directed towards terror. I'm looking at a report that the Bipartisan Policy Center put out last week, and they noted that throughout negotiations with Iran, the position of the United States has consistently been that we would only lift nuclear-related sanctions as part of a final agreement. Given the complexity of the U.S. sanctions regime and numerous overlapping reasons for which sanctions have been placed on Iran, distinguishing between those measures which are and are not nuclear-related will pose a significant challenge to the deal's implementation. They continue with their analysis, and they say out of more than 800 entities listed for sanctions relief under the JCPOA, the Bipartisan Policy Center analysis finds a total of at least 81 agencies, companies, and persons that were sanctioned for reasons that are either explicitly non-nuclear or could be contested as non-nuclear. These include entities that have been involved in developing ballistic missile systems, weapons smuggling, supporting terrorism, and violating human rights. Under a strict interpretation of what constitutes nuclear-related sanctions, these entities should not be subject to sanctions relief. Mr. Dubowitz, I wonder if you might want to comment on that and give me your opinion on how much of an issue this is.
Thank you, Congressman. I think it's a big issue, and I think what the administration has done is that they've started to try and recharacterize non-nuclear sanctions as nuclear sanctions so that they could provide sanctions relief under the JCPOA. Let me give you an example. Ballistic missile financing, right, was considered to be a separate example of illicit conduct. And so there are a number of designations of Iranian banks. The designation of the Central Bank of Iran included in on its predicate the financing of ballistic missiles. But the administration had a problem, which is that the Iranians were demanding in negotiations that a number of these entities be de-designated, including the Central Bank of Iran. And so what they've done is they've taken ballistic missile financing and they've recharacterized that as nuclear financing.
Well, you might think you might have gotten a concession if you're releasing a terrorism-related sanction or a missile-related sanction, that you would have gotten a commitment from Iran, for example, that they'd stop exporting terror.
Well, that's true, but I think what we've got to be careful of here is because the administration is saying we retain the right to designate on terrorism and human rights grounds, but the fact of the matter is that terrorism and human rights sanctions, for the most part, are not economic sanctions. And as a result, what we're effectively doing is we're dismantling the economic sanctions regime while still retaining the right to go after Iran for terrorism and human rights purposes. The problem, if we ever try to go after Iran for anything that's considered economic, the Iranians will point to the agreement and they will say there was a clause in there that you promised not to interfere with the normalization of trade and commercial affairs. Exactly. And they will say that basically we retain a nuclear snapback to walk away from the agreement. So we've dismantled the economic sanctions regime, and the administration has done that by recharacterizing effectively non-nuclear sanctions as
Thank you. That's one of the issues I think people really need to take a look at as they look at this agreement. I want to direct this one to Mr. Berman. Earlier this year, the G20, whose 34 member countries constitute the world's major financial centers, met in Istanbul and committed to take action to more aggressively combat terrorism financing around the world. The G20 enlisted the assistance of the Financial Action Task Force, which will hopefully issue a report later this year on how to prevent terrorist organizations from using the global financial system for fundraising. Should the JCPOA be implemented, how much damage does it do to this effort by the G20 and the FAFT?
Well, thank you, Congressman. I think it does a considerable amount of damage because the sheer volume of potential funds that will be transferred from Iranian coffers to its terrorist proxies inevitably will complicate the analysis of the Financial Action Task Force, and also strain existing mechanisms to monitor and interdict.
Well, how much easier is it going to be for Iran to launder money through the financial system to fund its terrorist proxies under this agreement?
I think that's a good question. I'm going to defer to my colleague, Mr. Dubowitz.
Well, I mean, the problem is that FATF at the end of the day has fundamentally actually depended on American financial sanctions power. So on one hand, you could say that because we retain U.S. financial sanctions, we still have power. On the other hand, it also relies on the ability to get other nations to go along with us. And what we've effectively done under this sanctions regime is we've dismantled the EU sanctions. The EU's they're lifting all of their sanctions because the majority of them are nuclear sanctions. And so as the Europeans go back to business, the Chinese, the Russians, and everybody else, it is going to be much more difficult to seek the kind of consensus that we need at FATF in order to actually crack down on Iranian illicit financial flows, because our very partners are going to be so deeply invested in the Iranian economy that it'll be more difficult than it has been in the past to persuade them to enforce these regulations on their financial institutions.
I see my time's expired, Mr. Chairman. I yield back.
Chair now recognizes the gentleman from Arizona, Mr. Schweikert, for 5 minutes.
Thank you, Mr. Chairman. And I'd like to ask a UC to put some documents into the record in regards to the charter of SWIFT.
Without objection, they're received.
Thank you, Mr. Chairman. Mr. Dubowitz, you're the only one up there who has actually talked about SWIFT, and this is something I've been trying to get my head around and wanted to focus on just for a couple moments. First, in 30 seconds, 20 seconds, describe what's the backbone of what SWIFT is.
So, Congressman, if I want to wire money to you, I'm going to wire money from my financial institution to your financial institution. SWIFT provides the financial messaging codes that essentially allow my financial institution to identify my bank account and identify your bank account at your financial institution so that wire transaction can take place. SWIFT is the international backbone and the global standard for financial messaging that facilitates financial flows around the world.
Okay, and the secure international backbone of electronic movement of money. Simple enough, and Belgium chartered. So walk me through a conceptual idea. Let's say this agreement moves forward, and all of a sudden Iranian institutions, banks, others that actually would have had a SWIFT membership would be able to move money. Except for the fact that if I'm here reading the SWIFT charter, both a country and an institution have been involved in bad acts don't have rights to access that system. So what happens here? I have here where we're obligating ourselves and countries to this agreement. At the same time, I have a private electronic backbone moving money that's not allowed to do this. But that's the first question. How does that end up working?
The issue is that under SWIFT bylaws, they can deny access to any financial institution that brings the SWIFT system into disrepute. SWIFT connects into something called Target 2, which is essentially the EU's equivalent of the U.S. FedWire. Under Target 2's bylaws, it said that no bank engaged in proliferation-sensitive financing, terror financing, or money laundering should be accessing Target 2 through SWIFT. Of course, that fit Iran to a letter, which is why ultimately in 2012, EU regulators ordered SWIFT to de-SWIFT designated Iranian banks. The problem, now they're going to de-designate all of those Iranian banks, including the Central Bank of Iran. EU regulators will, whether they order or strongly suggest to SWIFT that SWIFT re-SWIFT or allow them back into the SWIFT system. And by the way, there are a lot of bad banks on the SWIFT system. There are Russian banks, as I mentioned, who are still there. But the problem has been that the Russian banks that are still there, as I mentioned earlier, the head of VTB Bank of Russia said, if you de-SWIFT my bank, that's an act of economic war. So the problem is SWIFT, I think, will allow these banks back on. Once they're back on, it'll be very difficult to de-SWIFT them again, despite the bylaws, because the only thing that ultimately got SWIFT to move was congressional pressure in 2012 threatening sanctions against SWIFT that led to a chain reaction of de-SWIFting.
And we've been trying to also understand is the chartering country, which is Belgium.
Correct.
Do its laws end up affecting here? And my fear is if there's a change of government in Iran, or something happens, are they able to make an excuse at some point saying, you haven't given us full access to the world's financial systems, we're going to blow up the agreement on their end?
Oh, if I'm Iran, that's exactly what I'm going to do all the way through this process. I'm going to keep claiming that I'm not getting sufficient economic relief. Because the sufficiency of economic relief is a relative basis. So what Iran will do is claim that they're not getting it, and then they'll use that as excuses to not actually fully comply with their nuclear obligation.
Not to allow an inspection. I'm just seeing this sort of tit-for-tat negotiations coming out of nowhere. Also, the fact of the matter is, and forgive my language, sort of the bastardization of the movement of electronic money and the ethics that we, particularly in this country, have been trying to drive into this. And now we're about to say, oh, except for in this case, ignore the bad acts. Use the international system that we've helped create, and it's okay to move at least these bad actors' money.
Well, to me, this is essentially this is dropping a bomb on Treasury's mandate, because Treasury was set up, TFI, the Office of Terrorism and Financial Intelligence, was set up to protect the integrity of the U.S. financial system, the global financial system, from bad actors. It wasn't set up to get a nuclear deal. It was set up to protect the integrity of our financial system from money laundering, terror financing, proliferation-sensitive financing, and sanctions evasion. And by giving a nuclear deal to this nuclear deal to Iran and the dismantlement of our sanctions regime, we're effectively saying that it's not about conduct-based sanctions anymore. It's about a diplomatic achievement. Now, we made this mistake before with North Korea and Bank of Delta Asia. The North Koreans got all their sanctions relief, and they got a nuclear weapon, and we lost our economic leverage on North Korea. My fear is we're going to do the same thing again, and this has deep consequences for our sanctions programs writ large, including against Russia and other targets.
Mr. Chairman, I appreciate your patience. I'm just waiting for the day that we're going to owe a family or many families an apology because we allowed this backbone to finance some horrible act, and we allowed them to use our own systems. With that, I yield back, Mr. Chairman.
Gentleman yields back. The gentleman from Texas, Mr. Williams, is recognized for 5 minutes.
Thank you, Mr. Chairman, and thank all of you for hanging in there with us tonight. We appreciate it. I'm one of those that really wants to take care of America first and not Iran first. I think a lot of us here on the task force are concerned about trusting Iran. Obviously, historically speaking, many of us find it hard to believe that Iran will actually allow for an open and honest process when inspecting their nuclear sites. Determining how the JCPA will treat military site inspections is something I'm really concerned about. Most importantly, however, the fact that the President agreed to a deal that lacked inspection anytime, anywhere, I believe will have serious consequences. And I'm a small business owner myself. I make deals all the time. And I'm still concerned why we negotiate with when death to Americans and death to the Israelis is a common theme among the people we say we can trust. Now, my question to you, Mr. Heinonen, is the following. I've heard you say that the 24-day window will allow Iran to cheat, that Iran has not changed its nuclear course. It's keeping all the options open for building nuclear arms. Can you explain your comment?
Thank you, Mr. Congressman. And I perhaps use this opportunity also to clarify my rating, which Ranking Member Lynch asked earlier today. He asked me to rate the deal with a scale from 1 to 10. And as you see from my testimony, I actually have divided this testimony in 3 parts. One part is the declared facilities with declared materials. One is the rights and provisions to access undeclared activities where I raise those concerns. And then there is a third category, which I mentioned in my written statement, which are some other activities which are proscribed, like activities related to acquisition of computer software to design nuclear explosive devices, to certain multi-point detonation systems. When I look the rating for each of those, I think it's better to look each of those and you make your own risk assessment on that. The first one, when I set rating 7 to 8, this is for declared facilities, the way I see. And why it is not higher is because there is this dispute settlement process which you mentioned, up to 24 days or even more. But then if you ask me to give the rating for this access to suspected sites, undeclared sites, I don't think that I would give more than 5 if we use this rating. And then if you ask my opinion, which are the possibilities to find these computer codes and someone using them when there is actually even not really an inspection procedure for that, I think it's a 0, it's not even 1. So I think that this clarifies and answers to your concerns. And we need to keep also in our mind that the time is here of essence. This problem also changes with the time when Iran's capabilities increase. And just as an example, I'm not a sanctions expert, but yet when you come to year 15, when Iran can have any number of enrichment facilities, any place, perhaps a little bit deeper in ground than in Fordo, they can produce all enrichments they want, then the breakout time goes down, goes to the weeks, or even small. And then if you add this manufacturing of weapon components and others, they are prepared, that adds 2-3 weeks to this whole picture. I don't think that the sanctions have any meaning at that point of time because Iran already achieved what it needed in the worst case.
Next question, addressed to you also, sir. How important is it that Congress knows which military sites and scientists the administration intends to demand access to?
Well, that's a difficult question.
That's why I ask you.
Yeah. I think it's important for the international community to know these names and installations in public. And the reason for me is that there are some other states which may have information which, for example, United States of America government doesn't have. So by disclosing these names, these places, we achieve 2 things. We engage the other states to the process, and this reinforces the system and makes any concealment by Iran much more difficult. It also makes the verification system much more transparent when the names are known.
Thank you, Mr. Chairman. I yield back.
Gentleman from Arkansas, Mr. Hill, is recognized for 5 minutes.
Thank you, Mr. Chairman. Dr. Hinneman, I was interested in talking about, for a minute, the IAEA annexes to the agreement. Secretary Kerry really was quite dismissive of those in the briefing of Congress earlier this afternoon. What amount of importance should we put on the Iranian document with IAEA in terms of studying that as a part of fully understanding the verification regime, inspection regime?
I think it's one of the most important activities. I have been dealing with Iran 12 years in a row. And one of the most difficult things were to get things written down on the paper. What was not written, what was not specified, was allowed. So therefore, I think that all these documents should be available for IAEA member states. I don't see any technical reason why those should be secret information from the member states of the IAEA. IAEA Secretariat can perhaps give some of those information in technical briefings, but again, I think that the transparency of the process requires those to be disclosed so that we can see what kind of confidence level we have for this verification regime which is foreseen. And as I said in my statement earlier today, I think at the time from mid-August to mid-December is much too short to solve this PMD problem. And then I also pointed out that this IAEA is looking only information which is in the annex of November 2011 report. But Mr. Amano itself has said that there is some other information which came afterwards. And the way I read this JCPOA doesn't really give this opportunity to IAEA to go to verify at this stage that other information. Plus that knowing from my own experience from earlier years is that the IAEA puts the reports only information which it is sure at that point of time and information which meets its standards for the veracity of the information. So I'm sure that there were also some pieces which for those reasons Mr. Amano decided not to include to this program. So therefore I see that it's essential that the governments and the legislative parts will see those details so that they can do a full assessment what we can achieve, what we can not achieve, because after all, these are the elements of your risk assessment.
Right, and I feel like Secretary Kerry, as I said, Mr. Chairman, was dismissive, and I hope that you'll speak with Chairman Royce about making sure that we see these annexes and know the detail of the verification regime. A question for Mr. Berman. You were talking about the GDP in your written testimony and potential amounts of money that are being released. Give me some feel for the flow in addition to any near frozen money that's released, but what kind of monthly flow you think their revenue would be. And also tell me what you think the actual amount of foreign reserve should be for their belt and suspenders approach of having adequate cash on hand were snapback sanctions to come back. How much money would you estimate? 10% of GDP, more? What would you say?
I think that's a good question, and sort of it comes down to a sort of a term of art, calculus. I think the numbers that we heard earlier from other members of the committee, of the task force, when we talked about repatriation of sanctions or frozen funds that have already been released in the context of $12 billion to date. I think that's a useful barometer to look at. When we look at the sum of money that is expected to be provided.
So how much would you say would be in foreign, to be held in reserves? 10% of GDP? Would that give them that kind of a surety that they would, or would it be?
I think that's a reasonable estimate. My colleagues might disagree, might have a different estimate.
Well, just to give you a sense of this, in 2012, 2013, Iran's fully accessible foreign exchange reserves were $20 billion, an economy of about $350 billion GDP. And that's why they were 4 to 6 months from a severe balance of payments crisis. At the point where we could have actually accelerated the sanctions and brought them to severe crisis, we let up. We gave them $12 billion, which took their foreign exchange reserves, increased it by 60% to $32 billion. Now we're going to give them at least $100 billion. Now their foreign exchange reserves are going to get to $132 billion. And they're effectively gone from 6% of their GDP to almost about 40% of their GDP. So that what we've done is we've built up their foreign exchange reserves, which now increases their economic resilience. And with that kind of foreign exchange reserve rainy day fund, over time, it's going to make it very difficult for us to snap back sanctions and create the kind of economic pain in time. And Dr. Heinen is right. When they're an industrial size near zero breakout, days away from actually breaking out to a nuclear weapon, our ability to actually impose that kind of economic coercive force at that time will be significantly diminished because it will take much longer to have any kind of impact, never mind the impact we had in 2012.
Thank you. Thank you, Mr.
So, might I add one additional factoid just to sort of round out the discussion? I think it's useful to point out when we were having the earlier discussion about the amount of constriction that has occurred with regard to the Iranian economy as a result of sanctions, we heard about a fifth with regard to the constriction of Iranian GDP. If these numbers are anywhere near accurate, if we are indeed looking at $100 billion to $150 billion, we are actually providing or facilitating the expansion of the Iranian economy by a significant portion. We are wiping clean the constriction that occurred as a result of sanctions, and we're actually forcing an expansion. And I think that should be noted because, as I said before, money is fungible, and this expanded revenue is likely to trickle in various ways to Iranian regional activities as well as to terrorism.
Gentleman's time has expired. We'll now proceed to a second round of questions, and I would seek unanimous consent to do so. So without objection, I'll recognize Mr. Sherman of California for 5 minutes.
I've heard reports that Iran really has as little as 28 billion or as much as 150 billion. I'd like to know how much money they have on deposit, and then what are the obligations that the host bank or the host country is going to extract from that, because obviously nobody's going to give Iran its money if it owes it to a domestic vendor or if it owes it to the bank where they have the deposit. So, Mr. Nephew, how much do they have worldwide gross, and how much of that is obligated?
So, sir, thank you for the question. I would have to defer to the colleagues at the Treasury Department for a very accurate, specific set of numbers. I mean, my last information suggests, again, that they've got someplace between $100 and $150 billion in total reserves worldwide. Some of that is in Iran, and some of that is in...
When you say in Iran, you mean they have currency of another country in a vault in Iran, or they have their own money, which, of course, they have an unlimited amount of?
No, sir, that they've got some of other countries' currencies, as well as gold, which would also tend to count as reserves as well.
So excluding what's in their country, which obviously we're not giving back to them, what do they have outside their country?
So again, my estimate would only be preliminary. I have to defer to Treasury. I would say somewhere in the neighborhood of 100.
We're trying to get a straight answer out of Treasury is impossible, and at a classified briefing, it's almost impossible. So can you tell me what percentages in China, what percentages in Japan and Korea, what percentages in India?
So I would say a large percentage is in China, probably on the neighborhood of 20 to 30%.
Okay.
I would say that another maybe 20% is in Japan, and that the rest is spread between Korea, India, and Turkey, which are the other main oil importers from Iran. So
and none is in Europe because they stopped importing a while ago.
Right. There is some that is in Europe, but again, if we're talking percentages, you're probably in the single-digit percentages.
Okay, Mr. Haikonen, and this picks up on earlier questioning. We're being told that 24 days is enough because whatever Iran does is going to have this signature, and you're going to be able to tell that something radioactive was there. What I'm most concerned about is, can they perfect and create arrays of their IR-8 centrifuges? Now, in order to build these centrifuges, they're going to have to test them and calibrate them. Do they need to use gasified uranium to calibrate, or could they use an alternative gas in order to create an array of centrifuges that I'll call a virgin set? It's never touched uranium, there's nothing radioactive in the room, but they're ready to go.
Mr. Congressman, when you develop this kind of centrifuges, actually it's basically a three-step process. The first step is that you do what is called a mechanical testing. You just get them to spin and see that they survive long enough under this very severe conditions where they are running. The next step after that is normally that people use some other gas, like a xenon.
Like what?
Like xenon, which is a noble gas, to test the centrifuge, just to see that they work, because xenon has several isotopes, so you can see the enrichment factor. So this is very often the second step. And the beauty of that, if I may say, is that it doesn't cause any corrosion or this kind of things.
Inert gas, yes.
Yeah, inert gas. And then the third step is when you run, with the uranium gas to see that it still really works as it was designed. So one can...
Is there any substitute for the third step that does not leave a radioactive signature?
I don't think that you can perfect the centrifuge in such a way that it can survive in corrosive...
The 24 days might be long enough to catch them if they went to the third step. They can do computer modeling, obviously, we'd never catch that.
I don't think that this 24 days has much to do with that, because first of all, these things happen in different places. And when you go to this test, the last step of the test, you don't need to test so many machines. You
don't need to calibrate each one.
You need to use uranium hexafluoride. You need a room which is probably size of this. That's all what you need. And then if you have 3 weeks time to sanitize it, as Mr. Albright also agrees with me, it's doable if you do the planning in advance. And this is, I think, that we need also to recognize that when people talk about the deception techniques of Iran in 2003, they were ad hoc arrangements. They were caught by surprise. But if they have to do it today, they will have
You're
very
saying that
different
you could
actions.
actually use uranium hexafluoride gas
Yes.
in a centrifuge, in a room like this, and walk into that room 24 days later and not be able to detect that there had been any radioactive material in that room?
Yes, you can, but you have to plan it in advance how you dismantle it, and you can design it in such a way that this can be done swiftly. And want to remind that there were places in...
I would hope that you would issue a paper or something on this to get it the kind of definitive press coverage, because we're being told, and the American people are being told, that the 24 days is not too long, because if they're doing anything with uranium involved, it can be detected, and you're saying not if you plan it in advance.
Yes, and there were cases in 2003 that the IAEA did find in certain places enriched uranium, even though there should have been.
So if we just happen to bring a box of uranium into this room, hopefully without us in it, and then moved it out of this room in a few days, it's not certain that you could detect that uranium had been in the room?
Provided that you renovate the room.
Renovate the room. Okay. That usually takes more than 24 days, but this is the U.S. Congress. I yield back. And I'm referring to this exact room.
The Vice Chairman of the Task Force, Mr. Pittenger, is recognized for 5 minutes.
Thank you, Mr. Chairman. Mr. Hanlon, 20 years ago when we negotiated with North Koreans, we had the support of allies over there, and the Japanese should support it. South Korea. Is the world safer because of that agreement? Is the world safer because of the agreement that we have with North Korea that was negotiated 20 years ago?
North Korea, yes, I was actually involved myself from the IAEA side for the agreed framework. I think that the vision of the people who designed the agreed framework at that point of time was that the North Korean regime will not live very long time. So this agreement, which was has been now lasted 2 decades, was not supposed to last 2 decades, and that's why the provisions were like they were.
Excuse me, is the world safer today?
No, for sure not in North Korea.
That's my question. In my discussions with the IAEA in Vienna, my understanding is that they are limited when they have access just to those 17 sites. Is that correct? They can't go anywhere else in the country.
At this point of time, not, but when this additional protocol provisions and then these extra transparency undertakings by Iran will be implemented, IAEA can have access to additional places.
To the original places?
Additional places, like
predetermined, pre-agreed, but restricted to that, and not accessible to anywhere else in the country. No, if there's some other clandestine effort taking place, do we have access to go to other places besides those 17 approved sites?
The problem is that there are certain limitations for this access, which I have explained in my written testimony. This is not anytime, anywhere. You need to justify in writing why you want to go there and what is the information which drives to you.
But if I could just, for time's sake, is that clarified to just be the approved sites, those 17 sites? Can they say, we want to go to another part of the country?
According to this agreement, yes.
Okay. Since Iranians can stall through the ICPA for at least a month or more, in reality several months, how will we know if Iran is removing compromising material during this time? And how significant is this lead time? Does it compromise the inspection process?
Yes, it does, and this is the reason why I made the clarification to my statement with regard to the access of suspected and undeclared sites. There, the detection probability is much lower because of this time lag between the request of access and going there. And in addition to these extra justifications which IA has to give and which the counterpart can use to deceive the organization if it so wishes.
Okay, thank you. Thank you, Mr. Chairman. I yield back.
Gentleman yields back. The chair recognizes himself for 5 minutes. Mr. Dubowitz, the administration has stated that all sanctions relief is from the nuclear sanctions regime only. And after reviewing the list of entities and individuals de-designated, which I think you referred to in your opening statement, I think that was the list you referred to, and if it was, we want to include it as part of the record. My question to you is, do you agree with the administration's statement?
Well, as I mentioned earlier, Mr. Chairman, the administration is taking non-nuclear sanctions and recharacterizing them as nuclear sanctions. So if, on that basis, I don't agree with the administration. There were sanctions put in place that were not related to Iran's nuclear program. They're related to Iran's ballistic missile program, its money laundering, its illicit financial activities. And if you look at the Central Bank of Iran, which to me is the classic example of this, and there are other examples, but the Central Bank of Iran was designated, legislatively designated, and designated by the administration, and there was a finding under Section 311 of the Patriot Act, and there were numerous Treasury statements to confirm this. It was engaged in a range of illicit financial activities: nuclear, ballistic missile, terrorism, money laundering, sanctions evasion. And yet the administration is essentially allowing the Central Bank of Iran back in the global financial system. I disagree with Mr. Nephew. There were other ways to negotiate this. There were ways to actually allow the CBI back partially. There were ways to actually put down specific benchmarks and say to the Iranians, once you have established and met those benchmarks, then we will rehabilitate your Central Bank of Iran, but we are not going to wipe away all of these illicit financial activities just because we have a nuclear agreement. That could have been proposed and won in a negotiation. It is not good enough to say that the Iranians would have rejected it and therefore we took it off the table.
Why do you think that's happening?
I don't want to speculate in what's in the minds of the negotiators, and I have a lot of respect for the men and women who put a lot of years of their life into this, including Mr. Nephew. But I do think that we went into these negotiations, and I believe that the fundamental precept on the sanctions side was that we can sweep away these sanctions, but we will reinstate them if we have to. And that's the construct. The construct is we'll take them away and then we'll reimpose them if we need to. Instead of saying, how are we going to defend the sanctions architecture in key ways so that we maintain the economic leverage, particularly on the full range of Iran's illicit financial activities. And I've said to the Iranians, we'll give you relief here, but we're not giving you relief there until you establish that your banks are no longer engaged in the full range of illicit financial activities. That could have been a separate construct. I think we could have defended that. I think we would have had international support for that. But at the end of the day, the administration had a very different construct. Take it all away and reimpose it if they cheat.
My concern is that some of those de-designations may affect the rights of American citizens who have judgments against Iran. And Mr. Perlis and I, in my first round of questioning, we talked about the Beirut barracks bombing case that I believe you were involved in. We spoke off the record before the hearing about after September 11th, the district that I represent, Bucks County, Pennsylvania, had too many families who lost a loved one in the towers and in other places around the country. Fiona Havlish was a lead plaintiff in a case. I think Ellen Saraceni was involved in the case against the Islamic Republic of Iran. They did receive a judgment in excess of $1 billion, which is yet uncollected. I saw a congressional research list of total awards against Iran, and this, excluding punitive damages, just compensatory damages, exceeds $20 billion and doesn't even include the Havlish case from my district. So what message are we sending to, and I completely associate myself with the remarks of Mr. Green earlier about the 4 individuals who are hostage today in Iran, and we speak their names on the floor of the House, and we don't forget them, and we continue to work for them. But what message are we sending to the individuals that have claims and judgments uncollected against the Republic? Might those claims be wiped out as part of this agreement? Any of you?
As counsel for many of the claimants, and I spoke earlier with you off the record, we share an enforcement activity with the Havlish plaintiffs in the Justice Department in New York. The target of that enforcement activity was a skyscraper, 650 Fifth Avenue in Manhattan, that Iran was using as a money laundering facility. We sit at the knife's edge today, not knowing what the impact of this agreement will be on all of those enforcement activities. We don't know what instruction the administration will give to the Justice Department with respect to this joint seizure that we've done with the Havlish plaintiffs. We're simply stuck in stasis in this wait-and-see attitude. What we do know is, at least in the case of this bookkeeping entry system that we touched upon earlier, which is really the world's largest Hawala banking system. That's all it is at the end of the day, is the world's largest Hawala banking system. Federal judge in Manhattan last year asked OFAC to comment on the lawfulness of this Hawala system. This is Clearstream SA, a Luxembourg company owned by Deutsche Börse, running we tracked, I have no idea how much money really went through the account. We were able to track $1.67 billion of Iranian money going in and out of JP Morgan Chase by this bookkeeping system. And OFAC, frankly, declined to opine upon the lawfulness of that sort of transaction. From a practitioner's perspective, that's very frightening, because if a Clearstream can move Iranian money in and out of New York by book entry without it being a violation of law, the entire sanctions regime, and I'm not talking about Iranian sanctions, I'm talking about sanctions across the board, collapses. It means that any drug cartel, for example, could move their money to Luxembourg in a Gulf Stream and have a Luxembourg-based bank move it into the U.S. system by book entry. It's unreportable and untraceable.
Mr. Corliss, that skyscraper to which you refer on Fifth Avenue in Manhattan, New York City,
yes,
I believe is owned by Asa Corporation, which is
correct,
alleged to be a shell corporation controlled by Iranians.
That's correct.
My concern is Asa Corporation is on the list of organizations to be de-designated, which goes back to Mr. Dubowitz's concern. What does this have to do with nuclear sanctions, and what is really happening here, and what is the impact? But perhaps a subject for another hearing.
Mr. Chairman, if I could just add one quick thought. I mean, Mr. Nephew said we were going to give $100 billion of Iran's money back to Iran. It's interesting. I wonder if U.S. negotiators, maybe you could ask Secretary Kerry this, did they ever say to the Iranians, of the $100 billion that we're going to give you back, we're going to take X percent, and we're going to use that to satisfy the claims for the judgments of Iranian victims of terrorism. So before we give you money back so you can use it to create future victims of Iranian terrorism, you're going to pay those judgments out of that money. And we're going to give you, for every dollar that we give you, for every dollar that we take, we're going to give 80 cents back to you and 20 cents back to the victims of Iranian terrorism. Would have been an easy way to have settled this issue.
My time is well expired, and the Vice Chairman of the committee is recognized for the final question of the hearing.
Thank you, Mr. Chairman. Mr. Pearls, in representation of your clients, you made contact with OFAC, DOJ, the Solicitor General, as I understand, on behalf of your clients.
On a variety of matters related to, yes.
Seeking assistance in their behalf. Could you tell us the nature of that? We understand that your request was denied on one occasion at least, and you were rebuffed by them. Could you give us some context for that? And is this consistent with your previous work with the government? Have they been cooperative in the past, and why were they not this time?
Yeah, what we currently see, it could be more appropriately characterized as non-responsiveness. We just talked about the fact that a federal judge asked OFAC to opine upon the lawfulness of this gigantic Hawala banking system. We were in touch with OFAC after that request was made, and OFAC simply failed to respond. They had advised the federal judge that they were not going to respond. We had hoped to be finishing up our activities at the Supreme Court last spring. We're waiting for the Solicitor General to opine upon the constitutionality of statutes that you gentlemen passed to assist victims of terror. We're still waiting. I certainly hope that the Solicitor General will opine upon the constitutionality of those statutes this fall, but we have no schedule. We really don't know where we are. That is in very different contrast to where we were at the conclusion of the Bush administration. Stuart Levy, who I have enormous respect for, turned intelligence data over to us so that we could seize the $1.9 billion that was transiting New York. At that time, he said to us, your point of contact in the Treasury will be the General Counsel of OFAC. The General Counsel of OFAC gave me a phone number to call when I needed to reach him. It was always answered by a recording, and I always, without fail, received a call back from him within 10 minutes of the time I called. Now, we just don't see that anymore. It's just not happening.
So you've seen a reluctance on behalf of those who represent our government to assist American citizens in their claims against Iran?
Yes, sir.
Thank you very much. I yield back.
Gentleman yields back. I'd like to again thank our witnesses for their testimony here today. Without objection, all members will have 5 legislative days within which to submit additional written questions to the chair, which will be forwarded to the witnesses. I ask our witnesses to please respond as promptly as you're able. Without objection, this hearing is adjourned.
Good job, Steve. Thank you. It's hard testifying.
I got to testify tomorrow morning at 9 a.m. Bye, everyone.